What is maintenance and cure? That's our topic on this episode of Maritime Law TV. My guest is Houston attorney Terry Bryant, and he is known internationally for his work in maritime law primarily because he was the first attorney to file suit in the 2009 Somalia pirates case on behalf of a crew member. Terry, nice to have you.
Nice to be here, Cindy.
Terry, what is the doctrine of maintenance and cure?
Cindy, maintenance and cure are provisions for injured seamen or seamen that become ill while in the service of a vessel. What this means is that basically the vessel owner has a certain responsibility to the health and safety of his seamen while they are working on his ship. So let's suppose a seaman slips on the deck of the ship and breaks his leg. Under the doctrine of cure, the vessel's owner is required to pay for the seaman's medical treatment until the seaman reaches what we call maximum medical care. In addition, the doctrine of maintenance entitles the seaman to continue to receive his wages until the end of the voyage. Now let's suppose the seaman has to leave the vessel to get medical treatment. In that case, the vessel owner must also provide the seaman with enough compensation to pay for comparable room and board. In other words, the maintenance doctrine may, in some instances, provide compensation even if the injured or ill seaman has to leave the vessel.
Now, how is that maintenance level set? Who sets it? The vessel owner, or is this regulated in a manner similar to workers' compensation?
The Jones Act statute does not make it cut and dried, and that's why we recommend that you call an attorney to be sure that what you're being offered is fair and reasonable. Sometimes all it takes is a letter from a reputable law firm that handles Jones Act law to get the proper maintenance payments set up.
But if the matter does have to go to court, how likely is it that the seaman will have success?
Well, I can tell you that the courts do not have much sympathy for vessel owners that try to delay maintenance payments or set them at unfairly low limits. So with proper legal representation, the likelihood of a fair agreement is good. One of the things I feel is so important is that seamen understand their rights so that if they are treated unfairly, they recognize it immediately and can get legal help to protect their rights and any claim they have to compensation and payments for medical treatment.
I so agree with you, Terry, and that's really why you agreed to do this show with us, to help educate and thereby empower seamen and maritime workers.
You are correct. I talk to people and hear the horror stories of what happens when someone does not understand their legal rights. What happens so often is that they are mistreated and taken advantage of, and it's very disturbing to me.
It is to me as well. What I've seen during my 15 years in the legal industry is that without an experienced advocate in these situations, an attorney like you, big businesses do not ever just do the right thing.
Unfortunately, that's true. And for the most part, it's about money. They're in the business to make money, and I think along the way, many big businesses like ship owners all too often put profits over people. These corporations are just a piece of paper. That's all they are.
Terry, if someone has specific questions or wants more information, how can they reach you?
They can call us at 1-800-444-5000, or they can find us on the web at www.terrybryant.com.
Terry, thank you for your time.
Thank you, Cindy.
Until next time, this is Cindy Speaker for Maritime Law TV.